Hi, I'm Emily McFarling. I am a family law attorney in Las Vegas, Nevada, and I am going to be talking today about pensions, survivor benefits, QDROs, and the division of pensions and retirement plans in divorces in Nevada. So what we're going to cover today, we're going to go over the definitions and the differences between defined contribution plans and defined benefit plans and how they're divided in a divorce. We're going to go over what happens if someone delays their retirement, what are survivor benefits in a pension plan, and what's the community property interest in it. How you divide a pension or a retirement plan through what's called a QDRO or Qualified Domestic Relations Order. We're going to specifically look at Nevada PERS, the options available for survivor benefits in Nevada PERS, and how to handle those options in a QDRO. We're going to go over private pensions, which are under a law called ERISA, and then federal retirement plans, specifically the FERS and the civil service retirement system, and then the court orders acceptable for processing for those federal retirement plans, and then the form used to divide a military pension. So starting out, defined contribution plans. This is the term that's used for a retirement plan where you contribute money to it and that plan has a certain value to it. This is going to be like a 401k, a 403b, profit sharing, employee stock ownership, a thrift savings plan, an IRA. These are all plans that have a dollar value to them, and the benefit that you have in that account or that plan is something that actually is like, you know, hard cash, you know, after taxes and penalties, but it's a set amount of money. Now, the set amount of money can fluctuate depending on the stock market. So if you have your funds invested into some kind of trading or stocks, then they can fluctuate based on the market. And then these plans are usually tax deferred. We do have things like Roth IRAs where they're not tax deferred, where you pay taxes and then at the time that you put the money in, you don't have to pay taxes when you take the money out. But the majority of these defined contribution plans are tax deferred plans. And the risk of market fluctuations, of course, is borne by the person who's participating in the plan, as compared to retirement pension plans, where that risk really goes to the plan itself. So the division of defined contribution plans in divorce, if you have a 401k or some other defined contribution plan that you have been earning on and contributing to only during the time that you were married, that's pretty simple, right? In that situation, all of it is community property, and it would just be divided half-half between the spouses, unless you're negotiating it in exchange for something else. But the community value would be that, you know, each party gets a 50% interest in that plan when you're doing the calculations and the division in a divorce case. And if you have a plan that one of the parties had before marriage, that's where it gets much more complicated, because you have to figure out how much of it is community property and how much of it is separate property. And if you've had contributions that have been different over different years. You have a stock market that's gone up and down, and the amounts you put in and the earnings on it have gone up and down. It can be kind of difficult to trace how much of it's community and how much of it's separate. It can be done if you have all the documents going back from the beginning of that plan. There are financial analysts that can go in and actually map out exactly how much is community and exactly how much is separate property. But if you don't have all the documents, which is quite common when you have a plan that's from, say, 20 years ago, you might not have the documents from before marriage, then you're going to have to go in and do more guesstimates on how much is community and how much is separate property in that plan that somebody had before marriage and then was contributed to both before marriage and after marriage. Now, in doing a division of a defined contribution plan and a divorce, there's a few things you need to really be aware of logistically in how you're going to be divided up. So some plans can be divided up by the non-participant spouse opening up an account in their own name, and then the participant spouse just rolls over the amount that goes to the other spouse into that new account, and it gets divided that way. And so then both parties just each then have their own accounts. Now, when you set up the new account, generally it needs to be the same type of account. It needs to fit into the requirements for that plan that is being divided. So you're going to want to make sure that you're setting up an account that's going to be appropriate to receive the rollover of those funds from the plan that's being divided. Some plans require that you have a QDRO that divides the plan between the spouses. And so if you have one that requires a QDRO, then you're going to have this specific court order that spells out the division of it. And that's going to be what actually divides the account between the spouses. Now, you want to make really sure that you don't just withdraw the money from it. If you withdraw money from these defined contribution plans, generally they're going to have a early withdrawal penalty if you're under 59 and a half, such as with a 401k. And there also are taxes that attach to it whenever you make withdrawals. So if you're not planning if you're not fully prepared for the taxes and the penalties on it, you definitely don't want to be just withdrawing that money and giving it to the other party in a divorce case. Now, there is a very specific rule that allows you to avoid the 10% early withdrawal penalty if you're under 59 and a half in a divorce. So if you are under that age requirement and you want to divide up this 401k and the spouse who's receiving it wants to be able to withdraw it penalty free, then there's a mechanism for doing that. So you have to do it using the Qualified Domestic Relations Order, or QDRO, and it has to be done within a very specific time period following the divorce. You can't just do it anytime. You have to do it very quickly following that divorce. And if you do that, then you avoid the penalty for early withdrawal, but you don't avoid the taxes on it still. You still have to pay taxes on that withdrawal. So be very, very careful if you're trying to figure out ways to get cash out of a 401k in a divorce or any other kind of defined contribution plan. You want to make sure that you are dividing it correctly, either through a rollover or a QDRO, and you're not just withdrawing the money out unless you've really mapped out how this is going to work. You roll it over with the QDRO, and then you withdraw it penalty free, and you're following all of the rules and guidelines for that plan in order to make that penalty free. So pensions and defined benefit plans. So compared to a defined contribution plan where you're contributing a certain amount and it's accruing a certain dollar amount in that plan, a defined benefit plan is it's usually called a pension, a retirement. This is where an employer will have a retirement plan that is set up, and the plan benefit is a specific predetermined monthly income amount that the plan participant receives once they retire. And so it's not, there isn't some exact like value, this is how much you have in your plan, although they can be valued. But it's an entitlement to a monthly amount of money. The amount is typically calculated by the plan using a formula. It's based on the employee's salary, the employee's age, the years of service. And then because the monthly benefit is guaranteed by the employer, then it's not necessarily affected by stock market or any of those outside sources. And in the United States, most private sector defined benefit plans are insured by the Pension Benefit Guaranty Corporation. And so your plan benefits are often insured under these defined benefit plans. So how are defined benefit plans divided in a divorce? So unlike the defined contribution plans, which you really have to go in and do math and figure out how much was contributed, how much is each person's share, defined benefit plans are much easier to divide in a divorce. And we have a very set law in Nevada. It's very clear. This is one of the things that if you're going into a divorce and one or both of you have a pension, a defined benefit plan, pension or retirement account, that the law is super clear on what to expect on how much the other party is supposed to receive on it. And how they calculate that, it's called the time rule. So the time rule basically just takes the number of days that you were earning on that pension that you were married, and the number of days you were earning on that pension that you were not married, and calculates the other party's share based on that. And so let's say you were earning on a pension for 20 years and you were married for 10 of those years. So exactly half the time you were earning on the pension. So your spouse's community property interest is 1/2 of what you earned during the marriage. So if we're looking at a situation where you were earning for 20 years, you were married for 10 of it, and your spouse's interest is half of that time you were married, they would be entitled to 1/4 of that monthly amount. So if your monthly plan benefit, say, is $1,000 a month, in that math where you were earning for 20 years, you were married for 10, and your monthly benefit amount is $1,000, your spouse would get $250 and you would get $750 of that monthly amount in it. Now that's very simplified math on it, but that's how they do it. And it's something that there really aren't arguments to go and vary from this time rule. So it's very, very predictable. So unless you work out a settlement where you have negotiated for somebody to get less of a defined benefit plan than they're entitled to, unless you have agreed on it, the judge is going to divide the pension according to the time rule. Now, what happens if somebody is eligible to retire, but they have not yet retired, and they're already divorced? The non-participant spouse is getting a share of that pension, and they're waiting on it. They want that pension. They want to start earning that pension with the person retiring, and yet they're not retiring. So what do we do in a situation like this? So we actually have some case law in Nevada that's very specific on point. If you are the non-participant spouse, you're entitled to a share of that retirement, and your ex-spouse is just not retiring. Maybe they're holding out for a higher salary or something like that, or they just want to keep working. You can go into the family court, you can file a motion and ask that your monthly amount of that pension be paid out to you now at the time that you file the motion, not at the time that the person actually retires. Now, if you get paid out the retirement at because you filed a motion and not at the actual time of retirement, then that money has to be paid by your former spouse. It doesn't get paid by the pension plan, because the pension plan isn't paying anything, doesn't have an obligation to pay anything at this point in time. And now, if the person is continuing to work in order to get a higher retirement, let's say they want to, if they stay 3 more years, their retirement's going to be much higher than it was if they retire at their first eligibility. Then they can also ask that the amount that the person gets is going to be just based on what they would get at the current time of retirement. So if if the plan participant were to retire at the time they're first eligible, and they're going to be getting $1,000 a month, but if they stay and they work 3 more years, they're going to be getting $1,200 a month, and their ex-spouse files a motion saying, I want my money now, I want to get paid now because they're eligible to retire, then the judge in that case has the discretion. They have the ability to determine what the appropriate amount is. So you could end up just getting the $1,000 from there on out, instead of holding out 3 more years and getting the $1,200. And so that's something that it's not absolutely set in stone, but the judge has the ability to determine what the appropriate amount is when you're asking for money prior to an actual retirement. Community property and survivor benefits. So survivor benefits are when somebody has a pension and they retire, they are able to elect certain options for what happens if they pass away while they're retired. What happens to their benefits. So it's kind of like a life insurance policy, in that you can elect an option that says, if I die, then my benefits should go to this other person instead. So that's what a survivor benefit is. It's the annuity or the benefits that'll go to somebody else if the plan participant dies while they're receiving their retirement benefits. So under Nevada law, unless it's specifically spelled out in a decree of divorce, awarding a community interest in a pension plan does not entitle the non-employee spouse to survivor benefits. So if you don't have a decree of divorce that says that someone is entitled to receive these survivor benefits, then it's an error for them to be put into a QDRO thereafter. So you want to be really careful if you're preparing a QDRO following a decree of divorce. You're going to want to make sure that QDRO matches whatever the decree of divorce says as to the survivor benefits. Because survivor benefits are not something that are required for the court to order. So if you have people that are getting divorced and the plan participant is not yet retired, then the court can require that the participant designate their spouse as the survivor beneficiary, but they do not have to. There's no community property interest that requires the court to do that. It's something that can be done in very specific situations, but certainly if you're looking at a short-term marriage, you're looking at a situation where that spouse doesn't really have a very large interest in that pension. Maybe the parties are really young, they're really far off from retirement age. Those are not situations where the court is necessarily going to be looking at awarding a survivor benefit to a spouse. It's more going to be a situation where the parties have been married the majority of the time that the participant was earning on that plan. They're very close to retirement age, things like that. So there's no absolute community property interest in getting a survivor benefit in a division of a pension plan in a divorce case. What is a qualified domestic relations order, or a QDRO? A QDRO is a court order that's used to divide most private and state government-defined benefit plans between a participant and usually a spouse, but it can also be with a child, in the event of a divorce, a separation, or a support obligation. So a QDRO is really just a special type of order that has certain requirements in it that the plan wants in there so that the plan can do what they need to do. So a QDRO generally has to contain certain information such as the participants' information, name, last known mailing address, the amount or percentage of the participant's benefits to be paid to the alternate payee. And so you need to have enough information so that the plan can actually do the division of it. Now, a lot of pension plans will have a template QDRO that they can send you so that you make sure that you're putting all the information in there that they need in that QDRO. Or they might have a pamphlet that'll have a list of what has to be contained in the QDRO. A QDRO is not allowed to award any type of benefit that isn't actually available under the plan. And it must be submitted to and accepted by the plan administrator in order for it to be effective. So the QDRO, it's a court order that gets signed by the judge, and it's an order in your divorce case, but it has to actually be sent to the plan administrator, and the plan administrator has to approve it and say, yeah, this is good enough. This is what we need in order to buy this plan. And then they keep it in their files, and when the plan participant retires, then that QDRO directs the plan administrator to do whatever that QDRO says has to be done. Most of the pension plans that we deal with here in Nevada are pension plans under Nevada PERS. Nevada PERS is the Public Employees Retirement System of Nevada, and it's the defined benefit plan for Nevada government employees. There are 3 different plans that have slight differences between them. So there's the main plan, and then there's one for judicial, and there's one for fire and police. So if you're judicial or you're fire and police, you're going to want to make sure that you are reviewing the plan information for those specific plans and not just the general plan. For Nevada PERS specifically, the benefit amount is based upon the total years, months, and days worked, as well as the average of the highest 36 consecutive months of PERS eligible salary received while employed. So the amount of the benefit is based on the highest 3 consecutive years that the participant was earning on that plan. So a lot of people going into retirement are checking the timing of it. If they get a raise 2 years before they're eligible to retire, they might want to work 1 more year in order to get those 3 consecutive years in order to maximize that retirement benefit. On the PERS website, there is a benefits calculator. So if you're going in trying to figure out how much you might be getting, how much to expect in retirement, you can go plug the information into that benefits calculator on the PERS website and get some idea of what to expect for a retirement. And then the eligibility for benefits for Nevada PERS, the beginning of it starts at 5 years of service with a retirement age of 65 and expands from there depending on years of service and age. And so you're going to want to make sure that you're aware of what those specifics are for your specific type of Nevada PERS. So PERS has a list of specific options that are available for electing survivor benefits. Now, this is the benefit that you would give to a third party if the plan participant dies while they're receiving the retirement benefits. So the option for electing survivor benefits, it has to be elected at the time of retirement. So PERS has a specific list of options that are available to a plan participant for electing survivor benefits, meaning electing what's going to happen if they die while they're receiving their retirement benefits. So these options must be elected at the time of retirement. So when the plan participant is retiring, that is when they elect these survivor benefits, and they cannot be changed afterwards. They can't be added. You can't go in and add a survivor benefit after somebody's already retired. There might be very limited exceptions for being able to modify or change a survivor benefit that was elected, but for sure it's not something that can be added in after the plan participant has already retired. So if you're heading into a divorce case and someone is already retired, whatever they elected for survivor benefits when they retired, that's what you got. That's what's going to happen between those parties. So the specific options that are available regarding survivor benefits from Nevada PERS, option 1, which is called the unmodified allowance, it has no death benefit. So this means that if that plan participant dies, then their benefit goes away and that's it, and no one's going to be receiving any kind of beneficiary payment after the death of the participant. Option 2 is 100% of the benefit of that monthly amount that the participant was receiving continues for the lifetime of the beneficiary. So this one, there is a amount that you have to pay in order to receive the option 2 benefit. It's kind of like a life insurance premium, and it's deducted from the monthly plan benefit amount. But if that participant dies, then their beneficiary receives 100% of what they were receiving as the participant. Option 3 is similar to option 2, but it's only 50% of the benefit. So if the participant dies, then their beneficiary would receive 50% of what they were receiving as their monthly amount. And again, there is a fee that has to be paid in order to have this option 3 survivor benefit. And this benefit is paid for the lifetime of the survivor beneficiary, and the amount is actually based on the age and the beneficiary's age at the time of retirement. Then we have options 4 and 5, which are the same as options 2 and 3, but they're not payable to the beneficiary before the age of 60. And then options 6 and 7 allow you to designate a specific amount to be paid to your designated beneficiary. So each of these options, there's a cost that comes with it. There's an analysis done as to what is the monthly amount based on who your beneficiary is going to be, or you set a specific amount. But in general, because there's no community interest that requires that the court make someone a survivor beneficiary or designate someone as a survivor beneficiary, because you have to pay to get it. So this isn't something that you just get, it's something that you have to pay to get. And because of that, our Nevada courts have been very clear that there isn't a community interest in the survivor benefit in itself. So how do you handle selecting a survivor beneficiary option in a QDRO? So in a QDRO that is done after retirement, the option was already elected at the time of retirement, and that's what should be included in the QDRO. You should basically just memorialize what already happened, what the participant already selected as their option when they retired. If there's a QDRO that's being done before retirement, you can either require the election of a specific option, or you can be silent on the issue of election of an option. And so that's something that, as we discussed earlier, it has to match what was in the decree of divorce. So whatever the judge ordered or the parties agreed upon in the decree, that's what needs to go into the QDRO, whether it is the requirement of a specific option, or if there just isn't anything in there at all, which means that you're not requiring any specific option to be selected. So, different from Nevada PERS, which are the Nevada government employees, we also have private pensions. They're governed by federal statutes, which are called ERISA. ERISA is the Employee Retirement Income Security Act of 1974. And then they're also governed, of course, by the IRS, by the Internal Revenue Code. Our state laws in Nevada or any state cannot preempt ERISA. So whatever ERISA says about private pension plans, we can't go in and make statutes or have case law in Nevada that will supersede that. ERISA plans are divided through a QDRO in a divorce. The Federal Employee Retirement System, or FERS, is the defined benefit plan for military retirement benefits. They are subject to division in a divorce, except for one very specific situation. So if somebody is supposed to receive a military retirement and they elect to waive their retirement benefits in order to receive veterans disability benefits, those veterans disability benefits, even though they're being received instead of a military retirement, those disability benefits are not subject to a community property division in a divorce. So when you have a situation where someone has waived those benefits, or if you're doing a divorce in advance and you're anticipating that this could potentially happen, you have to be creative in figuring out how to make sure that the non-military spouse doesn't just lose all of the interest that they otherwise would have had in that military retirement. And so one of the best ways to handle that is to look at awarding a monthly amount to the non-military member in the form of alimony. And that can be calculated based upon that veteran's disability benefit. So while you cannot divide disability benefits as community property, you can take them into account. You can award alimony that takes into account the disability benefits that that military participant would be receiving. Now, the survivor benefit plan in the military permits a military retiree to elect a survivor beneficiary and award it to a former spouse. This election must be made in writing within 1 year of the divorce decree. The Civil Service Retirement System, CSRS, is the federal defined benefit plan for federal employees that are non-military employees. Now, in order to divide a federal defined benefit plan, you would use what's called a court order acceptable for processing, COAP, COAP. The court order acceptable for processing, it's the same concept as a QDRO, and it's the court order that is entered in your divorce case that would divide a federal employee defined benefit plan. So in order to be valid, it has to clearly identify the parties, the specific benefits to be shared, and provide sufficient information in order to compute the former spouse's share of the defined benefit plan. If you are dividing a military pension, those are divided a very specific way. So if you have been married for more than 10 years, then the division of a military pension is done through military form DD 2293. It's the application for former spouse payments from retired pay. And it's a form that you fill out. It's a very simple form. It gets submitted to the DFAS Office of General Counsel, and it will result in the direct payment of the elected amount to the former spouse from the military The form allows for the election of a dollar amount or a percentage of the military pension, one or the other. Now, it can only be used if the marriage is longer than 10 years. If you have a marriage that's less than 10 years, that spouse is still entitled to their time rule share of the military pension. It just will not be paid directly from the military. It's going to have to be paid directly from the participant's spouse. And so you have to do the calculations for how much the amount is in the time rule and make sure that that amount and that requirement is included in your divorce decree, and that it gets paid directly from the participant spouse to the non-participant spouse. So hopefully that was informative and helps you deal with what you need to do if you have any type of defined contribution plan or defined benefit plan, pension, 401k. And I'm Emily McFarling, and thanks for listening.